God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning. Welcome to the Appeals Court. I am William Meade. With me today are Justices Neyman and Walsh will be the panel for these two cases. Each side gets 15 minutes. You needn't use all of your time. There's no rebuttal. We've read everything, so my best advice is to get right to the point. With that, I'll call our first case, 24P 1364, Commonwealth versus Ortiz. Mr. DeMello.
Thank you, Your Honors. Kevin DeMello on behalf of the appellant defendant, Mr. Ortiz. Although Mr. Ortiz's DNA was found on a glove near the robbery, DNA evidence found on a portable item, even something directly connected to the crime like a mask or clothing or a glove, is not sufficient without additional evidence that the perpetrator placed the DNA on the object at the time of the crime. That evidence is what's missing in this case. As we know with the Anitas case, which I think is the most analogous case here that applies directly, you had a T-shirt and a bandana that was worn by the perpetrator. And I think the key to that case is that these are portable objects, and we know that DNA is durable, it's transferable, and just taking DNA, we can't tell when it was placed on those objects.
In Antius, wasn't it like the bandana and a T-shirt or something?
Bandana and a T-shirt, yes.
That were just found in some shared space.
They were found not quite at the scene of the crime.
Yeah.
But that's not really the central issue.
Here we found, they found the glove, one glove right near the house, another one along with a trail of the stolen materials.
Right. So
they're directly connected to the burglary.
So I think that's a bit of a red herring issue, because in the Anitas case, I think in the light most favorable to the Commonwealth, the bandana and the T-shirt, those were items that they knew were used in the crime. And if you look at the cases that that's based on, the Morris case, for instance, the fingerprint that was on the mask, they knew the mask was used in the crime. So if we have to concede in the light most favorable to the Commonwealth that these gloves were used in this crime, that's not the salient point. The salient point is, when was the DNA deposited on those gloves? I mean, there's all kinds of scenarios that we can come up with, but the idea in Anitas is that these articles of clothing were somewhere else and were brought to the scene. When they were somewhere else, that's when the DNA could have been put on them.
What was the crime in Anitas, or Anitas? I'm not sure how to pronounce it.
It was a robbery, Your Honor.
Was there evidence pertaining to the robbery found in Anitas near the items? When I say the items, near the items with the DNA on them or whatever?
I recall correctly, I think the items, the articles of clothing were found sort of in a parking lot that was like not too far from the crime scene.
But here, I think the distinction is that the fingerprints are found on gloves along a path with evidence from the crime.
Right.
Objects taken from the robbery here, or it's not a robbery, but from the B&E or burglary or whatever it was, strewn along this path. So isn't that a material distinction between this case and Anitas?
Well, maybe between Anitas. I'd argue that it's not, because it's not the key issue. In Morris, it's pretty clear that the mask that they're looking at that has the fingerprint on it was used in the crime. That's not the issue. The issue is that these are portable items, and DNA can last for a long time. It can be transferred.
Can I focus on that for a minute? Doesn't this hurt your argument, though? Because I can understand, and help me understand how this helps your case versus hurts your case. In the instance of a bandana and a sweatshirt, your argument is that, and what the case stands for, is that who knows when this DNA was deposited on the headband, right? The bandana and the sweatshirt, right?
Right.
And so it's just not enough to say this DNA, because these are portable. These people, right, who wore the sweatshirt, who wore the headband or whatever. Aren't gloves different? Like these types of gloves, at least? I mean, it's not as if there's 10 people that might have been wearing the sweatshirt or the bandana or whatever. It seems to me like these types of, was it a latex glove?
I believe so.
Right. Generally, right, isn't that a different type of article that, well, sure, it's portable, but the idea behind DNA is that, okay, you wear it, some DNA comes off, and then somebody else wears it and now is implicated in a crime, versus a latex glove seems to me like if there's DNA inside that glove, it doesn't hold the same weight as the argument as clothing.
I agree that if it were an article of clothing, I'd have a better argument.
Okay.
But a glove is still portable, and it's still reusable. It's very possible that someone puts on a latex glove and then discards it, and someone else picks it up and uses it. The other thing is, we don't know where the DNA was found on the glove. Was it found on the outside? Was it found on the inside? I don't think we have that information in this case. So if the DNA is deposited on the outside of the glove, I mean, this glove might never have been worn by my client, or at least there's not proof of that in this case. And
We also have the footprint that matches the defendant's shoe size, right?
well, I think there are three problems with that. First is the quality issue, which we'll pass lightly over that. I think I addressed it in my brief, but light most favorable to the Commonwealth. Let's say this thing, the shoe print was actually 11 and a half. There's no testimony here that says that the length of a shoe corresponds with the size of the shoe. And the detective was asked that question.
Those would be good jury arguments, but as you started to say, in the light most favorable to the Commonwealth, we've got a shoe print that matches the defendant's shoe. That's what the testimony, or shoe size.
Well, I'd push back on that, because I don't think that's what the evidence says. The evidence says we have a shoe print that's 11 to 11 and a half inches long. What we don't have is a measurement of the actual shoe. Is it 11 to 11 and a half inches? We know from the pictures that the tread is not.
What was the testimony?
The testimony was the defense counsel directly asked Detective Ramos, does shoe size correspond to the length of the print? And he said, I don't know.
What was his testimony before that?
I'm not sure exactly what you're referring to.
That it was the same size as the defendant's shoe.
Well, he never actually saw the shoe. He only got pictures.
Did he testify it was the same size?
I don't think he did, Your Honor. I think he testified that the size of the shoe, the size of the print was 11 to 11 and a half. He called the jail to ask what the shoe size was. They sent him photographs of a shoe that had a tag on it that said 11 and a half. There are no measurements of that shoe. The detective never actually had that shoe in his possession to make those measurements.
Was that evidence admitted without objection?
Which evidence?
The evidence to which you just referred?
I believe it was.
Let me ask you about the statement from the defendant to the officer that he had denied being in Leominster.
Sure.
What does that add to the calculus in your view?
So I don't think it adds anything, because the judge, initially it was objected to as hearsay. The judge sustained it, and then the Commonwealth said, well, no, we're actually we're not offering it for its truth. We're only offering it for proof of the intent to permanently deprive. So the judge let it in for that limited purpose. So I don't think that adds anything. You can't rely on this for the truth. It's not in evidence for the truth of the matter asserted.
I didn't see that objection, but perhaps it's in a
I can
different part of the
give you the
transcript.
page number.
Yeah, I'm looking at trial transcript page 49 and 50.
If you look at page 47, I think that's where the objection takes place. At least that's what I have in my notes.
That was with regard to the gun being located in Worcester.
Right.
Okay, what I said is, what about the defendant's statement to the officer that he had denied being in Leominster?
Oh, I'm sorry. I was confusing that with
That's okay.
another issue. Again, I would say that doesn't necessarily add anything to the calculus, because just because his DNA is found on a glove in Leominster doesn't mean he was there. He might be telling the truth. Maybe he discarded that glove somewhere else. Someone picked it up and used it in this crime.
Right, but in the Lattimore analysis, we don't exclude all relevant or possible hypotheses. We look at in the light most favorable to the Commonwealth. Doesn't someone saying, I've never been in Leominster, yet their DNA is found in Leominster at the scene of the crime, carry some weight? Again, I understand that you're taking issue with the significance of it, but doesn't it add to the calculus under the required finding standard?
Well, I don't think it does, because that's the Anita's case. I mean, the Anita's case says that the DNA on the item isn't enough to prove that they were there. You need independent evidence that they were there. So here, the DNA on the glove doesn't prove that my client was there. It just proves that a glove with his DNA was there. And it's a portable item. We don't know when that DNA was placed. We don't know where it was placed.
And your answer actually begs my final question, which is Anita's your best case, or do you have any other case that you think helps you more or equally?
I think it's the best case. I do think there's another case that might be instructive because it talks about shoe prints. It's the Commonwealth versus Strong case. It wasn't cited. It's 495 Mass 119.
I have it right here. Thank you.
In that case, they talked about having an expert who took all these shoe prints, matched the treads. And I'd actually like to go back to the shoe print issue again, because in Strong, the defense counsel argued the same sort of Anita's argument, and I think that applies here. Yes, there's a shoe print there. We don't know when that was placed there. We have no evidence that it was placed there at the time of the crime. And in fact, you've got other people walking around. The person whose house was robbed, he's walking around. He has a girlfriend and a friend who are walking around. You've got a neighbor who's walking around. You've got all these people walking around. We don't know what their shoe sizes are. Maybe they're 11, 11 and a half. Maybe one of them is. Maybe they placed the shoe print there. So, you know, I think the quality of the shoe print evidence is.
Detective Ramos testifies that the shoe he measured was the same size as the defendant's shoes on page 48.
On page 48, it says what?
The measurements were the same for the impression and for the defendant's shoe.
I think
Like most favorable to the Commonwealth, Mr. DeMello.
But if you look at the total facts of this case, he didn't have the shoe. How could he know that?
Those are great jury arguments.
I don't think it's a great.
The fact finder can discount everything other than what I just said.
I mean, then they would have to disbelieve other parts of Mr. Ramos's testimony.
And they're free to do that.
So they would have to disbelieve that he didn't actually see the shoe, that he didn't actually have the measurements
All
of the shoe?
they would have to do is believe that the shoe measured the same size as the imprint.
Right, but how was that
Connects
measurement?
it to the defendant being there.
Right, but how was that measurement taken?
Again, jury arguments. That all impeaches his testimony, which is fine, but you can't do it on appeal.
I get what you're saying, Your Honor, and I appreciate it, but I just think looking at the totality of the facts here, I mean, he testifies that he never had this shoe in his possession. There was never a measurement taken of the shoe.
Didn't have to credit that.
I guess.
So if you could accept for a moment, and I know it's difficult, but that in the light most favorable to the Commonwealth, there's a picture of a shoe with an 11 and a half, and there's a measurement of a shoe print that is roughly 11 and a half, right? So there's something. Again, understand that you have some issues about how do you know that he really was an 11 and a half, but for a moment, isn't the distinguishing point about this case is that there was more than just DNA?
Well, there was more than just DNA in the Anita's case, and there was more than just fingerprints in many of the other cases that went the defendant's way. And in fact, I'd argue in the Anita's case, there was better evidence than you had here. You had surveillance that not only identified the gender of the person, identified what they were wearing, identified a vehicle that was connected to the defendant. That's all much better evidence than you have here. You have a shoe print that could have been made by anyone at any time that, yeah, may have matched. You know, even if we concede in the light most favorable to the Commonwealth, which we don't, but even if we conceded that it matched the shoe, it clearly, if you look at the photos, the tread doesn't match. The shoe that's in the photos did not make this imprint. You can very clearly see that from the treads. So I'd argue that this isn't sufficient evidence. It's less evidence than you had in Anita's. It's less evidence than you had in Morris and many of the other cases that are cited. With that, Your Honors, I'll rest on my brief.
Ms. Kennedy.
Ann Kennedy, Assistant District Attorney for the District Attorney's Office for the Middle District. Good morning, Your Honors. This court should affirm the defendant's conviction because the evidence, when viewed in the light most favorable to the Commonwealth, is sufficient to show beyond a reasonable doubt that the defendant was the perpetrator of the crimes of breaking and entering in the nighttime, malicious destruction of property, and larceny of a firearm. As this court has already pointed out, there was evidence of a trail of evidence surrounding the tip of the purple latex glove containing the defendant's DNA that showed that the defendant was the perpetrator of the crime. And when you view the evidence in the best light, the light most favorable to the Commonwealth, it was sufficient. There are just a couple points that I would like to address the Anitas case, and one of the reasons why I want to address that is I think this court has pointed out in various different ways how it was vastly different from this case. While DNA is portable, in this case, the DNA was found on a latex glove.
Inside or outside?
There's no indication. It was on a fingertip. It was on a piece of a latex glove on a fingertip. So there's no indication on the report whether that was what side of the glove that would have been in. But what I know in Anitas is footnote 11. And footnote 11 refers to cases wherein it might be deemed sufficient to show that the DNA, when the DNA was deposited because of the item. And they reference a case called State versus Freeman. And in that citation in the footnote, they say that the DNA arriving on this evidence in some innocent, it was impossible to do an opposite inference of the DNA arriving on the evidence in some innocent manner because it required an unlikely series of events. And so the DNA in State versus Freeman was deemed sufficient because it was found on tissue paper found underneath the victim. And they said, it's so unlikely that the DNA would have arrived there in different ways. And I think the latex glove is similar. As Justice Walsh, as you pointed out, this is something that you don't exchange with people. This isn't something that you wear several times. This is kind of like a single-use item, right? And given that, and given its location to all of the items found that were involved in the break-in and connected to the victim's house, that evidence proves that the defendant was the perpetrator of the crime and that DNA was deposited there at that time.
What significance, if any, do we attribute to the defendant's statement to the detective that he had denied being in Leominster?
I think that supports our position. If he had never been to Leominster before, how did as the prosecutor argued in closing argument, again, what brought that glove there? Again, you have the only way to say that this glove was brought there is you'd have to create this series of unlikely events. That's the only way the glove's getting there.
So let me ask the follow-up. This is trial transcript, page 50. The detective's testimony is, he had denied being in Leominster, and the only time he was ever in Leominster was during an incident where he was arrested, I believed, by the ATF. Does that arrest refer to the arrest in the present case or some prior arrest?
Your Honor, I am not sure on that. I don't want to make a statement. I think it's a prior arrest. I think he was in jail at the time that they obtained his shoes, so I think that might have been a prior arrest, but I don't want to, that's speculative. So also, given the footprint that was found outside, right outside the door where the incident occurred, and I will beg to differ with my brother, my understanding of the evidence is that the victim stated that he could not have possibly deposited the footprint there. The victim stated that he noticed the footprints before he even went outside to further investigate the break-in, and the police said the same thing. I believe Officer Dion testified that he had yet to be outside when they noticed the footprints that were leading up to the embankment, and it happened to be a rainy, kind of muddy situation. So If there are no further questions, the Commonwealth asks that this court affirm the defendant's convictions, and the Commonwealth will rest on its brief. Thank you.
Thank you. Thank you both.
Thank you.
Our next case is 24P599 Commonwealth versus Santana. Ms. Goldblatt.
Good morning, Justices. Attorney Dana Goldblatt for Mr. Alejandro Santana. I want to start with the charge of receiving a stolen motor vehicle, because this is the prototypical case of somebody found driving a motor vehicle with no physical evidence or reason to believe that that motor vehicle was stolen. All of the factors that the court used in Commonwealth versus Hunt to find that the vehicle, there was enough evidence of a stolen vehicle, of knowledge of the stolen vehicle, are missing here. There was no attempt to conceal the vehicle.
Can I interrupt for a moment? So we're talking on the sufficiency of the evidence on
Yes.
the charge of receiving stolen motor vehicle. Thank you. So in the light most favorable to the Commonwealth, it's not about what isn't there necessarily, it's what is there. He's wearing rubber gloves?
He's wearing rubber gloves while engaging in what is clearly an attempt to get rid of evidence on behalf of his friends who had just committed the robbery. So this is a case where the rubber gloves are certainly consciousness of guilt, but they're not consciousness of knowledge that the car is stolen, because he is engaged in accomplice after the fact behavior on an independent crime.
Could be both.
Yeah, you don't get to pick which inferences we have to draw.
Of course, I wouldn't tell you which inferences you have to draw. I would just argue about when you have one crime and you have evidence of the mental state of that crime, can you extrapolate? Is the jury permitted to extrapolate? Is that sufficient evidence of any other crime? So can we add in other crimes as well?
We have more, though, right? Don't we have the additional implausibility that his friend, who shall not be named, lent him the truck, and he eventually admits to the police that he knew it was stolen?
He actually didn't admit to the police he knew it was stolen. That's actually a misrepresentation, which is why I filed the actual audio of his interview. He had already been arrested for stealing a motor vehicle when he was being interviewed. And the police said to him, well, you're driving a stolen car, right? And he said, yeah. And the police said, so you're effed, right? And he said, yeah. Now, clearly, by the time he had been arrested for driving the stolen motor vehicle, he knew it was stolen. That's something that he would have figured out from being told that he was being arrested for driving a stolen motor vehicle. It does not prove that he knew it was stolen before then.
Yeah, again, what you're saying is one plausible inference for what his statement was. Another plausible inference is that he knew it was stolen because he stole it or received a stolen one.
I think it wouldn't be that he stole it. I don't think that was the evidence.
I misspoke.
Received it. So the receiving charge is, by that logic, we could say, well, he's driving it, right? And he's arrested for driving it, so he's receiving a stolen car.
And you know what? There's a bunch of cases that say exactly that. That is a fair inference that someone in possession of stolen property is the receiver.
In Commonwealth versus Hunt, the appeals court said the defendant's possession of a stolen vehicle standing alone cannot support an inference beyond a reasonable doubt.
But this guy's wearing neoprene gloves while he's driving, too.
Yes. So the question would be, can possession of a stolen vehicle while wearing neoprene gloves?
And stating he knows it's stolen.
I do want to push back on that. Once you've been arrested for stealing a car, for driving a stolen car, you would of course know it was stolen. There has to be some evidence before.
You're pushing back, but what is the exact testimony? I know it's from the interview. What was he asked? What did he say?
The police said to him, well, you were driving the stolen car, right? And he said, yeah. This is after he's been arrested for driving the stolen car.
Understand the context.
Yes.
What did he
And they
say?
say, so you're effed, right? And he says, I guess, yeah. So the argument,
The audio is difficult, and I appreciate having the ability to listen so intently a number of times on exactly what was said. And it's also because he's wearing, when I say a mask, not a mask, but a mask, if you know what I mean, right? That it makes it difficult to hear. But at one point in time, and I just re-listened to it again before I came out into oral arguments, he does make the statement, and I would push back on a misrepresentation. He makes a statement that I was driving a stolen car, but I didn't know the guns were in there, right? Is what he says.
Yes.
In that mumbled voice. So the Commonwealth is not inaccurate in saying he said he was driving a stolen vehicle. And as Justice Meade said, whether you argue, well, he knew it now or he knew it before, is an inference with the evidence that could be argued. It wasn't like, oh, we have an admission. He says, yeah, I knew this was stolen while I was driving it. They didn't claim that. They said he made a statement that it was stolen.
yes, of course, and I'm not arguing that they've done anything unethical by pointing that out. I'm just
I thought you were.
No. I'm just arguing that the fact that someone knows a vehicle is stolen after they've been arrested for stealing it is not a reasonable inference to say that they also knew it before. It's just not a reasonable inference, so we can't attribute it to the court, and that's what I'm arguing. It reminds me of that scene in My Cousin Vinny, where they ask him, you shot the sheriff.
Shot
and he
the
goes,
clerk.
I shot the deputy? And then they read it out, I shot the deputy. Well, it's not a fair inference at that moment that he's confessing to shooting the deputy. Similarly, it's not really a fair inference at this, to be told you've stolen a car and that you've received a stolen car, and then be told, well, you have the car, right? He says, yeah, and it's stolen, right? Sure. To believe that, to make any inference about what he knew before he was told.
So possession, so he's in possession of a stolen vehicle.
Yes.
He is wearing the gloves, the rubber gloves, right? And he gives some, friend gave it to me, statement.
Yes. Friend later, and the friend testifies that that's true, that he did give him the car to use, that the friend is the one who stole it and gave him the car to use, and so that's true.
Right, but you say that that's insufficient as a matter of law.
Yes. Under Hunt, which says that possession alone is not enough, you don't have any evidence that would allow an inference of knowledge before the arrest. And neoprene gloves on its own in this context are just not enough. Because, and you can see the difference in what he's lying about too. He's lying about the firearms, right? He's like, oh, I didn't know that the firearms are there, and he's been convicted of basically being what should have been, I think, an accessory after the fact for moving the firearms. But he's not lying about the car or any of that. The gloves are for the firearms. And it's, again, we don't have to infer that the gloves are for the firearms. What I'm saying is that you can infer that somebody who's wearing neoprene gloves is committing a crime. But it's not enough to say this particular knowledge.
What about the fact that this merry band of burglars had stolen another car earlier that morning? Or
Again, I don't think he was involved in that, and there's no evidence that...
he most certainly was involved in that. He rode in the van, didn't he?
I'm sorry?
Wasn't he rode in the van, or saw them piling the guns in the van?
Yes.
And he moved the white van.
And he moved
from
the
one
Yes.
spot to
That
another.
was
Sorry to
that was
interrupt.
stolen too.
Yes.
And then his own car got towed, and he's left without a car, and all of a sudden, this truck shows up, right? Can't the jury consider that as well?
A pattern of receiving stolen items.
In this context, I would argue that that's not a reasonable inference, and here's why. These are kids with cars. These kids all have cars. The one who doesn't
They're
is...
not theirs, that's the problem.
No, he has his own car, right? And he socializes with other people who have his own
But then
car.
he lost his own car,
Right,
and
he
he
lost
has
his own car.
nothing, and all of a sudden, a stolen motor vehicle he's driving in, right?
And he is given that car by the person in the group who does not have access to his own car and keeps stealing cars.
But
Now,
doesn't
the
he use
idea,
that truck to shuttle the people back and forth between the hotels or motels, whatever?
yes,
Yeah, all part of the same operation,
yes.
which includes stealing vehicles.
It doesn't, because it's only this one kid who's stealing vehicles, and it does seem to be on these facts that he's
Well,
stealing
the van
them
is
to-
stolen,
Yes.
and the truck is stolen.
Yes, the truck he's driving was
Oh,
stolen, yes.
Yeah, my point is that this overwhelming pattern of conduct of them involved in this criminal enterprise, which includes stealing motor vehicles.
That is a misrepresentation of the enterprise.
It was certainly a part of the enterprise.
No, there's one kid who's trying to keep up with the others, and he keeps stealing cars so that he can bring a car to the thing. Like,
But
it's not the same. They're not planning to steal cars.
Excuse me, they all use the stolen cars.
They all use each other's cars. But there's no evidence that this is a scheme to steal cars or a plan to steal cars or that they're
I
doing
wasn't
that.
saying that at all. I'm saying it's a pattern of conduct that involves stealing motor vehicles to carry out this horrible B&E and assault on this couple.
There was no, because the one person who's stealing the cars, this is why it wasn't charged as car theft for all of them, right? Because the one person who's stealing cars, they don't have any knowledge of the stealing of the cars. There's no evidence of it. My client is charged with the things that they were doing together.
They got kicked out of the defendant's house for some reason. I don't understand this part of the record, but I don't think it's important. But they said, you know what, we need money and we need cars. And so they go and steal the white van. He grabs the keys and comes back, and they use the white van to drive to Ashland to do the B&E. The defendant's there.
He's not there.
He later moves the white van. He's wearing a mask.
I want to correct the record without feeling like I'm arguing with you.
Oh, you're
and I
arguing.
definitely
You're
don't.
supposed to argue.
So there's a couple things that you said there that aren't accurate. And one of them is that he was stealing cars. And he just wasn't. There's one kid who's stealing cars.
Again, you keep missing the point.
Yeah.
The group has stolen cars. He wasn't charged with stealing a car. He was in receipt of the stolen truck, which was part of the operation that involved stealing other people's motor vehicles to carry out these crimes.
The reason, and I'm just pushing back and saying the reason he wasn't charged with theft of a motor vehicle is because that wasn't part of the things that they could reasonably prove knowledge of, because it was something that this one guy was doing on his own to sort of keep up with the other kids who had cars. So this is different than the overall scheme, which was to go into the house, right? The overall scheme to go into the house was accomplished jointly, and the stealing of the cars individually. So that's part of what I want to push back on. I also want to...
Can one be charged, convicted of receiving stolen property as a joint venture?
I think so, yes.
Is the record clear here as to whether he was convicted on an individual basis or a joint venture basis for receiving stolen property?
The argument was all that it was that the argument before the jury was entirely
The
that
argument,
this was this one car.
it's the evidence, so I guess.
There was no
my-
evidence of joint venture of receiving stolen motor vehicle. I'm arguing there wasn't even evidence of him receiving it because he didn't know it was stolen. The kid with no car is doing a lot to keep the other people from knowing he has no cars. Like, he's working hard to keep up. Like, that's what the evidence is showing, not that they're all helping the one kid with no car mask the fact that he doesn't have access to cars, right? So then you have this group that forms a plan to go into houses, and that's what gets charged jointly.
Given that we have 2 minutes left, can we switch gears for a moment to talk about the statements? Would you agree, first of all, that it's an abuse of discretion review standard?
For the second, yes, sorry, abuse of discretion for both, yes.
And for the first statement at the Monticello Inn, it wasn't objected to, correct?
No, I think the second one wasn't and the first one was.
So the Daniels was objected to, the
Okay.
two Daniels. The first one was not objected to.
Yes, that's right. The first one was at the
being-
Monticello and not objected to. The second one was.
Okay, so different standards of review if we get to error, correct? Can we talk a moment about your argument that it was a narrative,
Yes.
right? And so how do you define narrative? Because when we look at I think it's Robinson, not Robertson case.
Confusing.
With the Merck, right? How do you square that away with your argument here?
That in Robertson,
Robin.
which is the murked one, the individual is saying to somebody else who's part of the conspiracy, this is what happened, so that they will know how to proceed.
The statement was admissible as a statement attributed in furtherance of a conspiracy.
Right.
Right? And so how is that different than I hit an old man and the gun jammed? Those are, in essence, the statements. How do you differentiate those, given that in Robinson it was admissible?
In Robertson, it was admissible because it went to somebody who was part of the conspiracy and therefore was understood to be a reason to conceal, right? So they're explaining what happened to other members of the conspiracy so that they can all make a plan. And that those statements are considered more reliable because this is part of the planning. Statements made to third parties who are not part of the conspiracy.
You're considering your client a third party?
No, it wasn't made to him. It was made to the driver, who testified that he was not part of the conspiracy. He was the Commonwealth's witness, and he was the one who, so it's made to him as the driver, right? So they tell the driver to go, and the driver goes. And then after he goes.
It's a van of conspirators, co-venturers, and he's saying what happened as to the reason why they got to get the heck out of there, right? And go, because this just happened. And I almost, I tried to shoot him, and I had to hit the old man.
That last part, where that's the reason to go, is not factually supported in the record. And the reason is that the witness specifically testified that they said, go, 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 and hit him. And only after he was driving and they're heading back to the hotel did they start to regale him with their exploits. And they start to tell him what happened. So this is that, and to me, that's the distinction between, and there's no evidence.
That into a narrative. So in other words,
Right.
narrative to me seems like after the fact, some time, not as they're driving and peeling away and saying, whew, this just happened, like he's murked, right? A narrative to me seems like later on in the case in which the individual tells the common law wife about what happened, who wasn't involved, some time passes. And, hey, let me tell you what happened at this address, right? Factually, it seemed different, but I see that the time is up.
Is it your position that the joint venture was over when they left the house?
No.
So the ongoing joint venture. So
It
these
just didn't
statements are
involve
made during an ongoing joint venture.
There was a joint venture, it just didn't involve my client. He was on a ride-along. So there's two elements. It has to be during the joint venture and during the defendant's participation.
He was a lookout at the scene. One could conclude that he was a lookout. Then he helped shuffle the cars. He moved the van. He was wearing a mask. So thank you for your argument.
Thank you.
Ms. White-Spate.
Good morning. May it please the Court, Hallie White-Spate, Assistant District Attorney for Middlesex on behalf of the Commonwealth. First, I want to thank the Court for its flexibility in accommodating us with the change of counsel and my sister counsel as well. And apologize in advance for any lacunae in my own preparation. I got this case late. Fortunately, ADA Ferreter did a great job on it. I don't know where the Court wants to start. With regard to the receiving stolen motor vehicle charge, I will just say there is the statement that his friend gave it to him, but he doesn't know his friend's name or he can't say his friend's name. This is certainly evidence of knowledge that it was stolen, trying to shield his friend from culpability. There is also the fact that not only is there a long pattern of stealing motor vehicles in this case, the defendant was out with Nada de Oliveira looking for the cars and weapons and whatever else they needed to carry out this scheme. De Oliveira testified, a bunch of us went out to find a car and whatever we needed, and the defendant probably does not appear to have been with him when he actually found the van, but he was definitely part of that expedition. So there's not just evidence of car theft by the group, but the defendant is there all along. And I don't recall, again, I read the transcript quickly, I don't recall Nada de Oliveira ever testifying, I really didn't want them to know that I had stolen these cars because then they'd know I didn't have a car. It seems to me it's very clear from the beginning what they're all doing. And the testimony is that the defendant was participating in those conversations at the Monticello Inn. The defendant was also the one who had the strongest personal interest in getting some cars and some money because he'd just been kicked out of his house. Moving to the co-conspirator statements.
Do you agree with Attorney Goldblatt that one of the statements was properly objected to and the other was not?
That's my recollection, yes. That the only thing that was objected to, and there was extensive discussion about those, it was the statements in the van after they came out of the house. I just don't recall whether the other, the testimony that there was a conversation ongoing about how we would get some money by going into a house. I don't recall an objection to that. But it doesn't matter, because even for all the statements, there's ample evidence that there was a concerted, combined plan to do this crime, and the defendant was in on it.
Did they choose this house in particular?
That is a mystery to me, Your Honor.
Use GPS to get there.
Yeah, they seemed to know where they were going, and I have a vague recollection of somebody testifying that somebody said, quote, the old man had a safe, but I could not point you to that in the transcript, and I don't think it's, I'm not going to try to top a My Cousin Vinny reference, but I might be thinking of In Cold Blood.
But In Cold Blood and My Cousin Vinny today.
That's what happens when you call special sessions. There does seem to have been, they do seem to have gone specifically to this house, but why is not clear to me. Now I've lost my train of thought.
Sorry to jump around, but when he's interviewed about the car that belongs to his friend who won't be named, does he ultimately admit that it's stolen, or is he just saying it's stolen because they charged him with it being stolen?
I have to confess, I could not get audio on the interview, and I had IT.
What does the officer testify to? The defendant said.
My recollection is that he just plays the audio. Does he testify?
Okay.
I don't think he repeats what the defendant
okay.
said. But so I can't speak directly to, like, what's the defendant's affect, what's his intonation when he says that. Is it a sort of resigned, well, you got me, if you say it's stolen, it must have been stolen. But again, this is the light most favorable to the Commonwealth, and the question is not, do we agree with this? Could a jury go into the deliberation room and draw completely opposite inferences and say, I don't think he was admitting to it, he looks like a nice kid, I don't think he knew about it, we're going to find him not guilty. And the jury did, in fact, acquit the other defendants. So they certainly knew how to distinguish between somebody who they thought really had the requisite intent and somebody who maybe didn't. But the question is, could you let the jury consider this? Could this go to the jury? I think we lose sight of that in sufficiency arguments sometimes. Is there a reasonable universe like the one we live in where a rational person could look at this evidence and say, yeah, all the elements are satisfied? And I think that's absolutely the case here. Certainly there was probable cause, again, in the light most favorable to the Commonwealth, that there was an ongoing joint venture. that the defendant was involved from the beginning, and that these statements were not just some, idle chit-chat after the fact. Oh, you know what happened last night? It was so funny, let me tell you about it. It was, no, this is really serious, and we're in some deep stuff here. We need to get out of here. And then, later the defendant's taking a very active role in finding a way to get rid of the guns, to move everybody out of the hotel.
You said probable cause. Did you mean preponderance?
I mean a preponderance of the evidence. Thank you very much, Your Honor. I'm usually more careful about that. I apologize. Yes, preponderance of the evidence. But again, I think we have ample evidence beyond a reasonable doubt when you look at all of it. That there was contrary testimony that the defendant's counsel elicited from Nada de Oliveira on cross-examination, that the defendant wasn't involved in the discussions. Fine, we ignore that. That Nada also testified, I didn't know what was going on. I thought we were going to buy weed. Not really all that plausible once you look at the fact that they all pile out of the van and the two Daniels have large shotguns and go into the house. And nobody says, hey, what are you doing with those? Wait, this isn't what I signed up for. Geez, I got to get out of here. There's no testimony about anybody questioning or resisting or trying to get away. And if the court has no further questions, I'll rely on the brief and ask the court to affirm the judgments. Thank you.
Take that under advisement. That'll bring to a close our session. I'd like to thank my panel, our clerks, the court officers, the clerk's office, and everybody else. Thank you. We'll see you in recess.
All rise, please.
Our excellent time.